Hello and welcome to Drishti IAS. This is Dr. P Jha, and today we'll discuss another important topic of Indian polity, that is theory of basic structure. This is the most important topic of Indian polity, and multiple questions have been asked both in prelims as well as mains examination for civil services. Now, what is the meaning of basic structure? What led to the origination or origin of this theory? And what were the incidents, what were the developments that prompted Supreme Court to deliver this historic judgment? Let us start. There is one part in our Constitution and that is called Part 3. Part 3 of our Constitution, which is considered as the most important part, because Part 3 talks about fundamental rights. And the Constituent Assembly, our own Constitution, Article 13, Article 32, Article 226, Article 142, and multiple judgments of Supreme Court and various high courts, they have established that these fundamental rights are sacrosanct, transcendental, and essential for the overall human existence. Without these fundamental rights, we cannot ensure a dignified life to our fellow countrymen. So Part 3, that is why, is considered as the cornerstone, and that is why these rights are called fundamental, means basic. And we have numerous Supreme Court judgments where Supreme Court has established the supremacy of these rights. So Part 3 out of 24 parts of our Constitution is the most, or is considered as the most important part. But at the same time, in the same Constitution, we have another provision, that is Article 368, which provides amendment procedure. And Article 368 authorizes Parliament, that Parliament has the authority to amend the Constitution. So, Article 368 relates to amendment provisions. These two provisions of our Constitution, Part 3 and Article 368, eventually led to the advent of theory of basic structure. Because Part 3 talks about fundamental rights and Article 368 gives power to Parliament to amend the Constitution of India. So if Parliament can amend the Constitution, and this Constitution also contains fundamental rights, so the question before Supreme Court, which came The question before Supreme Court which was raised, that can fundamental rights be amended using Article 368? Because if you can use Article 368 and if you can amend fundamental rights, then what is the meaning of those rights to be called as fundamental? Then it simply means that those rights are dependent on the wishes, on the will of the Parliament. So this question was raised, and that case was Shankari Prasad in Shankari Prasad case. This question was raised for the first time because the full name was Shankari Prasad versus Union of India, 1951. Why this case was filed? Why this question arose? Because in 1951, by first Constitution Amendment Act, Article 31A and 31B, these two articles were inserted in the Constitution. And again, since our topic is theory of basic structure, I will not go into detail of these two articles, but in nutshell, these two articles altered. These two articles sought to amend the provisions of fundamental rights. And that is why this question was asked in Supreme Court, that can fundamental rights be amended under Article 368? That case was Shankari Prasad versus Union of India case, 1951, because in 1951, by first Constitution Amendment Act, two articles 31A and 31B were inserted in the Constitution. Now, in this case, Supreme Court judgment was yes. Yes, Parliament can amend fundamental rights. Then again, same question was asked in Sajjan Singh versus State of Rajasthan, 1964. In this case also, Supreme Court took the same view. The view Supreme Court had taken in Shankari Prasad, same view was taken by the Supreme Court. And again, Supreme Court said, yes, Parliament can amend fundamental rights using Article 368. But when third time the same question was asked, Golaknath case, and year was 1967. The same question, that can fundamental rights be amended using Article 368, was raised again in 1967. Why this question? Why this case? Why this question? Because 17th Constitution Amendment Act. Because of this act, because of this amendment, because 17th Constitution Amendment added certain laws under 9th schedule. So when 17th Amendment was passed by the Parliament, same question was raised before Supreme Court. And in Golaknath case, Supreme Court reversed its earlier decision given in Shankari Prasad and Sajjan Singh case, and Supreme Court said no, Parliament cannot amend fundamental rights. And Supreme Court went one step ahead. Supreme Court said that title of Article 368 is procedure to amend. It does not say power to amend. That means Article 368 contains only procedural part, and it does not confer any power on Parliament to amend the Constitution. So, the basis of Golaknath case was title of Article 368. This title was procedure to amend. The original Constitution, which was enacted on 26th January 1950, title of Article 368 was procedure to amend, and it did not talk about power to amend. On that basis, in Golaknath case, Supreme Court said that Parliament cannot amend any part of the Constitution, including fundamental rights. Then, when Parliament cannot amend any part of the Constitution, forget fundamental rights, then real difficulties started coming. Because we all know that no constitution can be static. Society keeps changing, society keeps evolving. And according to the changing challenges, we need to modify and amend our constitution. So when Golaknath case was delivered, that judgment was delivered, that Parliament cannot amend any part of the Constitution, including FR, then the problem is our Constitution would become a static document. Thereafter, to remove the difficulty created by the Golaknath case, 24th Constitution Amendment Act was passed. What happened by 24th Amendment Act? Original Article 368, the title was Procedure to Amend. Now, by 24th Amendment Act, one word was added, procedure and power to amend, because this was the ground on which basis Supreme Court delivered Golaknath judgment. I just said that the title did not talk about power, and that is why Golaknath case Supreme Court said that Parliament has no power, because title does not talk about that. Then Parliament added the word power. Word power was added under Article 368. Then comes, we have the third step. Then comes the fourth case, historic case, that is Kesavananda Bharati. (1973). In this case, three amendments were challenged: 24th, 25th, and 29th. These facts are important from prelims perspective. In Shankari Prasad, first constitution amendment was challenged. In Golaknath, 17th constitution amendment was challenged. And in Kesavananda, 3 amendments passed by parliament were challenged: 24th amendment, 25th amendment, and 29th amendment. In this historic case, (13-judge bench), largest bench of Supreme Court, 13-judge bench of Supreme Court propounded theory of basic structure, there were 13 judges in that bench and there were 11 judgments. 11 judges delivered their verdict. So Kesavananda Bharati case, what was the crux of this case? Crux was in this case, what Supreme Court did? Reversed Golaknath judgment, because in Golaknath, Supreme Court said that Parliament had no power to amend not only fundamental rights but any part of the Constitution. That judgment was reversed in Kesavananda, and Supreme Court said Parliament can amend. Parliament can amend any part of the Constitution, including a part. But at the same time, Supreme Court, after reversing Golaknath, Supreme Court propounded that Parliament can amend any part of the Constitution, including FR, but a big but was imposed by the Supreme Court, and by this word but, Supreme Court restricted the totalitarian power of Parliament. Parliament can amend any part of the Constitution, including FR, but Parliament cannot alter, emasculate, or abridge basic structure of the Constitution, so for the first time, Supreme Court propounded basic structure theory in Kesavananda Bharati case. So, Supreme Court took a middle path actually. First, reversed the judgment of Golaknath, which denied any power to Parliament to amend the Constitution, because as I said, that would have created problems. But at the same time, Supreme Court also restricted the authority of the Parliament, and Supreme Court actually established that whether Parliament, whether Judiciary, no organ is above Constitution. So you can amend the Constitution including FR, but you cannot amend, you cannot destroy, you cannot emasculate basic structure of the Constitution. Now the question is, what is basic structure? You cannot destroy basic structure of the Constitution. But a relevant question is, what is basic structure? Actually, there is no hard and fast rule regarding basic structure. Or I must say, not defined. So there is no authoritative definition of basic structure, but various features of the Constitution, those features have been recognized as part of basic structure. This is how 11 judgments elaborated on basic structure. There is no definition. Supreme Court has incorporated various features of our Constitution, and if I have to club all those features, there are altogether 16 such features. For example, supremacy of the Constitution, republican and democratic form of government, secular character of the Constitution, separation of power, judicial review, balance between part 3 and part 4, rule of law, unity and integrity of the nation, federal character of the Constitution, sovereignty of the country. Likewise, we have 16 such provisions: independence of judiciary, social, political and economic justice, liberty of thought, expression, belief, faith and worship, etc., etc. So till date, 16 such features, essential features of our Constitution have been recognized as part of theory of basic structure, as part of basic structure, which cannot be destroyed, altered by the Parliament. And when there is one more point in theory of basic structure, when Supreme Court reversed Golaknath judgment, Parliament got emboldened. And then what Parliament did? Parliament enacted 42nd Constitution Amendment Act. And by this amendment, clause 4 and 5, these two clauses were added under Article 368, which said that any amendment in the Constitution is immune to judicial review, because Golaknath judgment denied any power to Parliament to amend the Constitution. That judgment was reversed by the Supreme Court in Kesavananda. Then Parliament went one step ahead and Parliament added two clauses under Article 368, which say that any amendment to the Constitution cannot be challenged in a court of law. That means all amendments are immune to judicial review. Thereafter, these two amendments were declared as unconstitutional in 1980 in famous Minerva Mills case. Because in this case, Minerva Mills case, Supreme Court included judicial review as part of basic structure. And these two clauses, they were infringing upon the independence of judiciary. They were denying the power of judicial review to the Supreme Court. That is why these two clauses were declared to be unconstitutional by the Supreme Court in 1980 in Minerva Mills case, on the ground that judicial review is part of theory of basic structure. Now, if I have to conclude, multiple times it was asked from the Supreme Court that you have incorporated multiple essential features of the Constitution under basic structure, but you have not yet defined it. There is no authoritative definition of basic structure. Then how would you summarize it? Then the famous paragraph of a Supreme Court judgment which says, if the historical background, including Article 368, the preamble, the entire scheme of the Constitution, if we consider these aspects in totality, the historical background, the philosophy of our freedom struggle, the preamble to our Constitution, the overall scheme and provisions and intent of the Constitution, if you consider all these aspects in totality, Supreme Court says there won't be any difficulty in understanding what is the basic structure. What was the intent of the founding fathers of our Constitution? And what is the inherent philosophy of our Constitution? Easily you can understand if you have idea about the nature of our freedom struggle, the kind of diversity we have, the kind of cultural legacy we have inherited, the ethos contained in the preamble, there won't be any difficulty in deciphering what is the basic structure. So thereby I conclude my discussion, and again now I'll switch over to multiple choice questions. I'll read the question and I would ask you to reply in the comment box. theory of basic structure was propounded in Kesavananda Bharati case. Which of the constitution amendments were challenged in this case? Was that 24th Amendment, 24th and 25th Amendment, 24th, 25th and 29th Amendment, and was that First Amendment? You can give your answers in the comment box. Second, consider the following statements. In Sajjan Singh case, Supreme Court held that Parliament has no power to amend the fundamental rights. Second statement, in Shankari Prasad case, Supreme Court held that Parliament has the power to amend the Constitution. Which of these statements given above are correct? Only one, only two, both 1 and 2, none of the above. Similarly, you have to reply in the comment box. Then consider the following statements. In Golaknath case, Supreme Court held that Parliament has no power to amend the fundamental rights. Statement 2, 17th Constitution Amendment was challenged in Golaknath case. Same question. You have to select the right statement and reply in the comment box. Consider the following statements. Theory of basic structure was defined by the Supreme Court in Kesavananda Bharati case in 1973. The theory of basic structure does not apply on 9th schedule, which was inserted in the Constitution by First Constitution Amendment Act 1951. Select the correct statement. Now match the following cases with their corresponding outcomes. Kesavananda Bharati case, Indira Nehru Gandhi case, Minerva Mills case. Outcomes: established the basic structure doctrine, invalidated a provision of the 39th Amendment Act, and third, struck down a provision of the 42nd Amendment Act. You have to match these cases with the outcome. Arrange the following events in chronological order. Golaknath case, Shankari Prasad case, Kesavananda Bharati case, Minerva Mills case. In ascending order, which case was the first and which case was the last, that way. And last question is, which of the following statements about the basic structure of Indian Constitution are correct? It includes the principle of equality. It guarantees the supremacy of the Constitution. It restricts the power of Parliament to amend the Constitution. Reply in the comment box. Thank you so very much. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.